Hi, good day everyone. My name is Nurjana Yuaji. So for today's video, I will discuss about the 5 pillars of the Philippine criminal justice system. The Philippine criminal justice system is composed of 5 pillars, namely law enforcement, prosecution, court, correction, and the community. The law enforcement it is a first pillar in the prime mover of system, and the one who initiate the crime. The law enforcement it consists of the officers and men of the Philippine National Police or PNP and the National Bureau of Investigation or NBI in other agencies. When they learn the commission of crimes of discover them, their duty is to follow. Number 1, investigate the crime which may take the form of surveillance and observation of suspect. Other persons and premises interviewing persons with knowledge of facts directly or indirectly connected with the offense. The police officers, in other words, collect evidence for use in the prosecution of the suspects in the court. This may consist of the testimony of witnesses, including invited suspects, which are invariably taken down in question and answer form. Number 2, arrest suspects by virtue of a warrant of arrest issued by a judge on the basis of evidence submitted by them or under circumstances justifying a warrantless arrest. The function of law enforcement in general such as to prevent criminal behavior, to reduce crime, to apprehend and arrest offenders, to protect life and property, to regulate non-criminal conduct. The instances when an arrest without warrant may be lawfully effected by a peace officer or a private person are as follows. Number 1, when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Number 2, when an offense has in fact just been committed and he has personal knowledge of facts indicating that the person to be arrested has committed it. And lastly, when the person to be arrested is the prisoner who has escaped from a penal establishment or place where he is serving final judgment or temporarily confined while of his case is pending, has escaped while being transferred from one confinement to another. Any person who while in custody or otherwise deprived of liberty is under investigation for the commission of an offense has the following constitutional rights among others. Number 1, he must be informed of his right to remain silent and to have an competent and independent counsel, preferably of his own of choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing in the presence of the counsel. Number 2, no torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary incommunicado, or other similar forms of detention are prohibited, and any confession or admission obtained in violation of foregoing shall be inadmissible and evidence against him. Refer the case and the suspects of the office of the public prosecutor or municipal trial court for preliminary investigation, or directly to the municipal trial court for trial and judgment. Prosecution. The investigation and prosecution of all cases involving violation of penal laws are lodged with Department of Justice or DOJ through its National Prosecution Service or NAPROS. The DOJ is headed by the Secretary of Justice with 3 undersecretaries assisting him. Aside from the being prosecution arm of the government, the DOJ shall have the following in powers and functions. Number 1, act as principal law agency of the government and as legal counsel and representative thereof whenever so required. Number 2, administer the probation and correction system. Number 3, extend free legal assistance or representation to indigents and poor litigants, criminal case in non-commercial, civil, disputes. National Prosecution Service or NPS tasked as prosecutional arm of the government and under supervision and control of the Department of Justice. Functions of NPS. Number 1, to conduct preliminary investigation. Number 2, to make proper recommendation during inquest of a case. Number 3, to represent the government or state during the prosecution of a case. Number 4, to act as the law officer of the province or city in the absence of legal officer. Number 5, to investigate administrative case filed against the state prosecution. Prosecute criminal action. All criminal action either commenced by complaint or by information shall have prosecute under the direction and control of a public prosecutor. The private prosecutor may be authorized in written by the chief of the prosecution office of the regional state prosecutor to prosecute the case subject to the approval of the court. Preliminary investigation is defined when required inquiry or proceeding to determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Note: a prosecutor does not determine the guilt or innocence of the accused but merely determines the existence of probable cause. Kinds of determination of probable cause. The executive determination made by the prosecutor during preliminary investigation and by an officer when arresting under hot pursuit arrest. The judicial determination made by a judge to ascertain whether a warrant of arrest and a search warrant should be issued against the accused. When it is required. Under Section 7, a preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. Court is the government body officially assembled under the authority of law at the appropriate time and place for the administration of justice through which the state enforces its sovereign rights and powers. Functions of the court. Number 1, to protect the rights of the accused. Number 2, to determine by all legal means whether a person is guilty of a crime. Number 3, to protect the society. Number 4, to prevent and reduce criminal behavior. Number 5, administrative role. Venue refers to the place, location, or site where the case is to be heard on its merits. Jurisdiction, the authority of the court to hear and try a particular offense and to impose the punishment provided by the law. The judicial process is the preliminary investigation results in the finding that a crime has been committed and the suspect is probably guilty thereof. The public prosecutor will file the corresponding information in the proper court, thus activating the judicial process. The case shall then be set for arraignment, which is the first of a criminal action. It consists of a reading the information or criminal complaint in court to the accused in open court. What is correction? It is the community's reaction to a convicted offender. It deals with the branch of the administration of criminal justice changed with the responsibility of custody, supervision, and rehabilitation of the convicts. What is penalty? It is also known as punishment. It refers to the suffering inflicted by the state for the transgression of the law. It has been regarded by many as an effective means of social control through the infliction or paying every transgression of law. What is penology? It is the study of punishment for crime or criminal offenders. It includes the study of control and prevention of crime through punishment of criminal offenders. It can also be defined as the division of criminology that deals with prison management and the treatment of offenders, and concern itself with the philosophy and practice of society in its effort to repress criminal activities. They have 7 parts of the judicial condition of penalty. 1. Correctional. 2. Certain. 3. Commensurate. 4. Legal. 5. Equal. 6. Personal. And 7. Suffering. What are the purposes of correction and sentencing? Number 1. Deterrence. Number 2. Isolation. Number 3. Punishment. 4. Rehabilitation. And 5. Reintegration. What are the ultimate goals of correctional treatment? They have a 3 R's. Number 1. to reform. Number 2, to rehabilitate. Number 3, to reintegrate inmates to the community and become law-abiding and productive citizens. Penal or correctional process. Punishment is the isolation of the convicts by imprisonment for the periods laid down by the method prescribed by law, and correctional and rehabilitation are functions undertaken by the institutions set up law, such as the Bureau of Prisons, Parole, and Probation Administration. What is community? It is considered as the base and most important pillar because without its cooperation and coordination with the other four pillars, the ends of justice will not be served. After the convicts have passed through the correction component, either unconditionally as by full service of the term of imprisonment imposed on them, or by parole or pardon, they go back to the community and either lead normal lives as law-abiding citizens in their barangay, or regrettably commit other crime and thus go back through the same process and stages of the criminal justice system.